Hello viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. In this episode, we will be dealing with definitions of some new crimes that have been introduced in the Bharatiya Nyaya Sanhita. In the previous episode, we dealt with section 48, that is abatement of a crime in India when the abatement is done by a person who is sitting outside India. Then the changes that have been brought about in instances of cases involving marital rape, that is where the age it has been raised to 18 for married women also. Then we also discussed section 69, which is a new provision to protect women from being raped by obtaining their consent by deceitful means, such as by promising them marriage or promotion, or by getting their consent by misrepresenting the identity, such as when the man represents himself to be of some other caste, community or religion, due to which the woman gives her consent, whereas the accused has no intention whatsoever of keeping his part of the promise from the very beginning. That is when consent is obtained by fraudulent means, then in such cases such consent is negated. So, after dealing with all those provisions, now let us deal with another new section which has been introduced for the first time in our substantive criminal law, and that is section 95. Section 95 of BNS deals with hiring, employing or engaging a child to commit an offence. So, the law says whoever hires, employs or engages any child to commit an offence shall be punished with imprisonment of either description which shall not be less than 3 years, but which may extend to 10 years, and with fine, and if the offence be committed, shall also be punished with the punishment provided for that offence as if the offence had been committed by such person himself. See, what this provision says is whoever, whether it is a man, woman, trans person, whoever either hires a child, employs a child or engages a child to commit an offence. So, in any way, if you have drawn a child into a life of crime, into commission of a crime. Now, the definition of child is also very clear. It is any person below the age of 18 years. So, now whoever hires, employs or engages any child to commit an offence, then the punishment which shall be not less than 3 years. See, it could be simple imprisonment, it could be rigorous imprisonment, but it shall not be less than 3 years, but which may extend to 10 years. And what if the child has actually committed the offence? See, where the child has not committed the offence, he was merely hired, employed or engaged to commit the offence, that act in itself is a punishable crime. But if the child has also committed that offence, then the punishment would be even more. See, whatever is the punishment that has been provided for the offence that was committed by the child, then that punishment can also be given to the person who had actually engaged or employed or hired a child to commit that particular crime. The explanation says hiring, employing, engaging or using a child for sexual exploitation or pornography is covered within the meaning of this section. Now, this explanation was required in order to bring this provision in conformity with the provisions of POCSO. So, why did we need this provision? This was required because there are increasingly instances coming to the fore wherein we see that children of tender age, children below the age of 18 years, they are being increasingly engaged or employed by gangs to commit crimes for them. And why is this increasing? Because we got the Juvenile Justice Act, wherein the maximum punishment prescribed for a juvenile is 3 years. Moreover, we amended the Juvenile Justice Act, and now juveniles, they can be tried as adults. That is, minors between 16 to 18 years of age, they can be tried as adults. But that is permitted only in cases of heinous crimes. See, the Juvenile Justice, Care and Protection of Children Act 2015, it defines the term heinous crimes under section 233, clause 33 of the law as including the offences for which minimum punishment under the IPC or any other law for the time being in force is imprisonment for 7 years or more. So you see, a juvenile can be tried as an adult only when he has committed a crime which entails an imprisonment of 7 years or more. For crimes for which the punishment is less than 7 years, then in such cases, even if you engage a child, you have lured the child by providing money, by providing a promise of employment, or by promising to take care of the family members of such child, or sometimes by pressurizing the child, or sometimes by making a child a drug addict and thereafter compelling the child to commit such a crime. So whatsoever is the means that has been employed, what happens? Children, they fall easy prey because they feel that the maximum punishment to which they can be sentenced to under this law is maximum 3 years, and once you've completed the term, there is an absolute confidentiality also, because we do not maintain the records of our children who have been indicted in crimes, because they are allowed to make a fresh beginning. We are not supposed to stigmatize them. So what happens? All these kinds of progressive provisions which were meant to protect our children, who sometimes erred and sometimes ended up committing a crime, now these provisions, they are being misused by people to engage children in crimes. So in order to deal with such offenders, we needed to introduce the section 95 in the Bharatiya Nyaya Sanhita. Now let us talk about a new provision that has been introduced in offences affecting human body, and that is punishment for murder. See, punishment for murder is the same as was there provided earlier. But now what have we done? We have introduced a new subsection in section 103, and now that is one provision which will cover instances of mob lynchings, hate crimes, honor killings. So in all such crimes which would take place when suppose a young couple, a young girl or a boy was killed on the pretext of protecting the honor of the family, sometimes we would see that there would be people who would be subjected to hate crimes, or people would be lynched by mobs altogether. So now these were instances which were posing a threat to the rule of law. So what was required? That people would be saying that we need to enact a new law for them. Now what has happened in this? See, these are crimes which are premeditated, deliberate killings of human beings. So that is something which amounts to murder. See, that is not merely culpable homicide not amounting to murder. Wherever an act is done in a premeditated, deliberated fashion, moreover, when this act of killing is not covered under any of the exceptions provided for murder or any of the general exceptions that are provided under the BNS, then these are crimes which amount to murder. And when such a murder has been done in a manner that it could also amount to a mob lynching or a hate crime or an honor killing, then instead of making a separate law for that, what has been done? It has been introduced as subsection 2 of 103, and it has defined what would be the ingredients of the crime in order to be covered under that subsection 2, and the accused could be punished for that. See, punishment for murder, which is ordinarily prescribed under section 103 subsection 1, it is the same as was earlier under the IPC. It says, whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. Now coming to subsection 2, it says when a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. So now here what is required is that there has to be a group of people acting together, and the group should consist of minimum 5 people. Because that is what the law says. There should be a group of 5 or more than 5 people, and they should be acting in concert. That is, it should be premeditated, that there should be some express or implied agreement between them about the goal that they seek to achieve. So, when there is a minimum of 5 or more people who are acting in furtherance of such a goal, who are acting in concert, and when they commit murder, and the murder has been committed on the grounds of race, caste, community, sex, place of birth, language, personal belief or any other similar ground. So, what happens when the killing is on account of honor, when it is a result of hate, whatever it is, and when it is done by a mob of 5 or more people, then each member of such group shall be punished with death or with imprisonment for life, and shall also be liable to fine. See, this is something which already we had in the IPC, but it was not provided distinctly. We already had punishment for murder, and whenever we would convict a person for murder read with either section 34, which was common intention, or 149, which talked about common objective, then it would be the same punishment that would be awarded to each of the accused persons, irrespective of the part that was played by either one of them. Now see, why is such a punishment required? That is because when crimes are committed in a premeditated fashion by a large number of people, what happens, sometimes it becomes difficult to exactly find out which injury was inflicted by which person. Then sometimes people, when they are themselves not capable or they don't have the guts to commit a crime, they draw strength from large number of people who are working with them. So what happens? Such groups acting in concert, prior planning, none of them has a good sense that could prevail on him to explain to the others also that this is not done. They are all acting in concert. So it is all a deliberate, planned killing, and in such cases there can be no mercy that can be given to the accused persons. And that is why what the law says, each member of such group. See, in crimes they also serve who only stand and wait. So irrespective of the part that was played by either one of them, all of them would be liable to the same punishment, and the punishment shall be either death or imprisonment for life, and additionally they would also be required to pay fine. See, we already had certain guidelines regarding mob lynchings which were laid down by the Supreme Court in July 2018 while hearing 2 writ petitions filed by Tehseen Poonawalla and Tushar Gandhi against cow vigilantism. The court had held that the acts of lynching where private citizens take law in their own hands is illegal and it cannot be condoned. While passing orders, the court did not restrict itself to specific acts of cow vigilantism, but covered all acts of mob lynchings or vigilantism and issued the following guidelines. 1. There will be a nodal officer appointed in each district who is not below the rank of Superintendent of Police to prevent incidents of mob lynching and cow vigilantism. Within a period of 3 weeks from today, that is the date when these guidelines they were issued by the Supreme Court, the court said that the state governments are required to identify the affected districts where lynching incidents have taken place. An automatic FIR under section 153A IPC, that is promoting enmity between different groups, will be registered against individuals who incite people and spread fake news on social media. The state governments were also directed to prepare a lynching or a mob violence victim compensation scheme under section 357A of CRPC within 1 month from the date of this judgment. The court further held that the cases of lynching or mob violence shall be tried in fast-track courts in each district, and the trial has to be completed within 6 months. The court had also recommended in this case that Parliament should create a separate offence of lynching which should be duly punished. So, you see, the Supreme Court has powers under Article 141 to issue certain guidelines, and those guidelines they serve as law till the time the legislature does not make an appropriate law in this regard. So, these guidelines they were serving as law But now when the new law was enacted, these guidelines, in order to give effect to them, the state has introduced subsection 2 in section 103, which is punishment for murder, and now we have a separate provision to deal with mob lynchings also. Then, in addition to this, we have supporting provisions under the Bharatiya Nagarik Suraksha Sanhita section 33, which talks about duty of public to give information of offences punishable under specified section. The law says every person aware of the commission of or of the intention of any other person to commit any offence punishable under any of the specified sections of Bharatiya Nyaya Sanhita shall forthwith give information to the nearest magistrate or police officer of such commission or information. So, now this is a legal obligation, this is not merely a moral obligation. If you are aware of the commission of an offence, or if you are aware that some other person has an intention to commit an offence which has been given under the specified sections of BNS, so you are required to provide information to the nearest magistrate or the police officer. And what are the specified sections of BNS? See, there are many other sections also. Here we are dealing with sections 103 to 105, which are both inclusive, and such person shall give information as above in the absence of any reasonable excuse. That is, if the person does not inform, he should have some reasonable excuse or justification as to why he could not inform, because the law says if he fails to give information and pleads that his failure is due to reasonable excuse, then the burden of proving such excuse shall also lie upon him. So, for the purpose of this section, the term offence, it includes any act committed at any place out of India, which if committed in India would constitute an offence which is punishable under specified sections of Bharatiya Nyaya Sanhita. Then there is a duty on officers that are employed in connection with affairs of a village to make certain report. That is given under section 34 subsection 1 clause A of Bharatiya Nagarik Suraksha Sanhita. It provides that every officer who is employed in connection with the affairs of a village and every person residing in a village shall forthwith communicate to the nearest magistrate or to the officer in charge of the nearest police station, whichever is nearer, any information which he may possess respecting the commission of or intention to commit at any place out of India near such village any act which, if committed in India, which would be an offence punishable under any of the following sections of BNS, that is 103, 105, 111, 12, 13, 178 to 81, 305, 307, 309 to 312, clauses F and G of section 326, 331 or 332. See, in state of Madhya Pradesh versus Ramji Lal Sharma, this is a 2022 judgment of the Supreme Court in which the court held that once it has been established and proved by prosecution that all accused came at place of incident with a common intention to kill deceased, and as such they shared common intention, in that case it is immaterial whether any of the accused who shared common intention had used any weapon or not, and any of them had caused an injury on deceased or not. So, even if the accused wants to take the plea that, see, I have not inflicted any injury, still he would be held equally guilty. There is another judgment, 2009 judgment by the Supreme Court in Rajnath versus State of UP, wherein the court had observed that mere presence in an unlawful assembly cannot render a person liable unless there was a common object and he was actuated by that common object, and that object is one of those set out in section 141. Where common object of unlawful assembly is not proved, accused persons cannot be convicted with the help of 149. The word object means purpose or design, and in order to make it common, it must be shared by all. So, in other words, object should be common to persons who compose assembly. That is to say, they should all be aware of it and concur in it. A common object may be formed by express agreement after mutual consultation, but that is by no means necessary. It may be formed at any stage by all or a few members of assembly, and other members may just join and adopt it. Once formed, it need not continue to be same. It may be modified or altered or abandoned at any stage. So students, this was about mob lynchings. Now let us talk about a provision which has been put on hold. While the rest of the provisions regarding BNS would be implemented from 1st of July 2024, there is one single provision, section 106, related to causing death by negligence, whose implementation has been put on hold. See, what does the provision say? Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. So, what is required is that death of a human being, the death should be caused by doing any rash or negligent act, and such rash or negligent act should not amount to culpable homicide. See, if it is culpable homicide, if there are those degrees of intention or knowledge as is required to for an act to amount to culpable homicide, then the offence would be punishable therein. Here the act is covered only when the act was caused by rashness or negligence and the act does not amount to culpable homicide. Then in such cases punishment may extend up to 5 years. Earlier the punishment that was prescribed was 2 years, now it has been raised to 5 years. And further the law says, if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. See, earlier under the Indian Penal Code, medical practitioners, they were not specifically mentioned as such, although there was criminal liability for doctors who had committed some acts of gross negligence, and for that we had guidelines that were laid down by the Supreme Court in Jacob Matthews case. But as it is, the statutory provision did not refer to medical negligence as a criminal liability. Then the explanation says, for the purposes of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019 and whose name has been entered in the National Medical Register or a state medical register under that Act. Under subsection 2, whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident shall be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. So now this is a duty that has been imposed now. See, it was seen that there were so many hit and run accidents that were happening and there were a large number of people who were losing their lives annually to these hit and run accidents. So it was all there clear in the NCRB data. So it was required to have a law wherein we could minimize such casualties. How that could be done? If we could impose on the accused person an obligation that, see, even if you have to escape from the scene, you are supposed to report it to a police officer or a magistrate so that some help can reach the person who has been hit or injured in some accident. So in case you have caused the death of a person by rash and negligent act, but it does not amount to culpable homicide. So now you would be held guilty for causing death by rash and negligent act, but the punishment would be further increased in case you escape from the site without even bothering to report it to a police officer or a magistrate. So this is something which any good Samaritan is required to do. So earlier it was not a legal obligation, but now there is a legal obligation, and failure to fulfill such legal obligation would amount to a higher offence for which punishment may extend up to 10 years. Now section 106 subsection 2 has been introduced to cover the hit and run accidents and to ensure reporting of accident immediately. This has been introduced with an aim to save the victim within the critical golden hour. See, golden hour is a term which was introduced in the Motor Vehicles Act 1988 in the year 2019, and golden hour is the crucial time within which if the injured person gets some medical help, then there are chances of saving the life. Section 106, subsection 2 of the Bharatiya Nyaya Sanhita provides that whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident, then he shall be punished with imprisonment of either description for a term which may extend to 10 years. Additionally, there is also a liability towards fine. See, punishment under 106 subsection 2 is not attracted merely by virtue of driver escaping from the scene after the incident to escape the wrath of bystanders who might mob lynch him. See, offence is committed only if escape from scene is coupled with non-reporting by him to police or magistrate soon after the incident. See, many times people would say that, see, if we would stop there at the site of the incident, we would be subjected to mob lynchings. But now, from 1st July 2024, we are introducing provisions as to EFIRs and zero FIR. So, anyone can register information with the police. Whether you are at any place, you just have to make a call, you just have to go to the website of the concerned police station or the website of the state wherein you can register such EFIRs. What is required is that after registering such EFIRs, you are supposed to visit the police station within a period of 3 days and to put your signatures on the FIR so that the police may start investigation. But if the information has disclosed that there is an accident and there is someone who requires immediate medical attention, at least medical attention could be provided to such person. But since people were not aware of all this, moreover, we have to admit that sometimes our truck drivers, they might not be that tech savvy. So, in keeping with the concerns that were expressed by their group, this particular provision, this has been put on hold for the time being. See, even otherwise, when we talk about negligence, negligence is a concept which is usually applied in civil laws. So, in the case of Muhammad Ainuddin versus State of Andhra Pradesh in 2000, the court had held that principle of res ipsa loquitur, that is, the act speaks for itself, is only a rule of evidence to determine the onus of proof in actions relating to negligence. The principles have application only when the nature of accident and attending circumstances would lead to believe that in the absence of negligence the accident would not have occurred and the thing which caused injury is shown to have been under the management and control of the alleged wrongdoer. In Jacob Matthew versus State of Punjab, the court held that the word gross has not been used in 304 of IPC yet. It is settled that in criminal law, negligence or recklessness has to be of such a high degree to be gross. The expression rash or negligent act as occurring in 304 of IPC has to be read as qualified by the word grossly in order to constitute medical negligence. In Malay Kumar Ganguly versus Sukumar Mukherjee 2010, the Supreme Court held that standard of proof as regards culpability requirements under 304 of IPC stand on an altogether different footing. So, there is no comparison between the IPC and tort law or consumer protection law. We require a higher degree of negligence in order to impose criminal liability. Okay. So, these were the leading judgments regarding to medical negligence. See, even under law of tort, a medical practitioner can only be held liable in respect of erroneous diagnosis if his error is so palpably wrong as to prove by itself that it was negligently arrived or it was a product of absence of reasonable skill and care on his part regard being had to the ordinary level of skill in that provision. So, we require a high degree of negligence. In criminal proceedings under 304, degree of negligence has to be higher than the degree of negligence which is enough to fasten liability in civil cases. So, students, this would be all for this session. I hope you understood the relevant provisions and I hope you enjoyed the provisions, you enjoyed the session. Thank you so much. Have a good day.